Are you ready?
I believe so, Chairman.
Good morning. Welcome to Criminal Justice Full Committee. I'm glad you're here. I'm just telling you this is Criminal Justice Full Committee in case you're lost and maybe in the wrong room. So for those of you who will be staying, it is Tuesday, April 23rd, 2024. This is probably, unless something inadvertent happens, the last committee meeting we will have with the greatest committee that's in the House. Yeah. Madam Clerk, would you please take the roll?
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Towns, Vice Chairman Gillespie, Mr. Chairman Halsey. Mr. Chairman, you have a quorum.
Thank you very much. Members, do you have any personal orders before we start? All right. Well, we will take up item number 1, which is on our calendar. By the way, before we do that, hold on to that motion. House Bill 1947 is off notice. That is item number 3 on the calendar. Now that brings us back to 1. We did have a motion and a second on House Bill 1128 by Chairman Gant. You're recognized, sir.
Mr. Chairman, I want to make sure we have the correct amendment on here. I was talking to our good friend Representative Doggett this morning, and we want to make sure that we have the correct amendment. The amendment that should be on the bill is 018044.
All right, you have a motion and a second. I'm sorry, we voted it on last time.
Okay, that's why I wanted to make sure I was absent, and
Okay.
Representative Powers was kind enough to try to carry it for me.
All right, please proceed.
Mr. Chairman, what this bill does is the purpose of this is to provide data that will ensure the Attorney General has standing to bring suit against the federal government if it deems necessary. This bill does 3 things. It requires a jailer and arresting law enforcement agency to collaborate to verify citizenship when a person is arrested in the state. It requires the keeper of the jail to report persons who are not lawfully present, and it also defines not lawfully present within the United States. We know illegal immigration is not a victimless crime, and we are aiming to capture data in only a small portion of the number of illegal aliens in this state. The fiscal impact is not significant. The effective date of this legislation is this year, July 1st, 24. And the bill establishes that a person will be presumed to be not lawfully present if they cannot provide the following items: a verifiable Social Security card or number, a Tennessee driver's license or photo ID, a green card, permanent resident card, a student visa, a birth certificate issued within the United States, a valid unexpired U.S. passport, a certificate of citizenship, or a certificate of naturalization. And Mr. Chairman, before I go any further, I'll stop there and see if there's any questions that I may be able to try to answer.
All right, Representative Hardaway.
Thank you, Chairman. To the sponsor, if I was arrested with no ID and no papers, then I would be deemed to be illegal and would be reported to the AG as such. Is that correct?
Well, I think this is, it says it requires a jailer and arresting law enforcement agency to collaborate to verify citizenship when a person is arrested in the state. So I would say yes.
Sir, I can't vote for that. And you and I are friends, but
absolutely.
that smacks. Well, I'll just leave it at I can't vote for that. Thank you.
Representative Johnson.
Thank you, Mr. Chairman. At the very beginning, you said the purpose of this bill was to do what?
Collect data,
But you said something about suing the federal government.
possibly, yes.
Okay.
Is there some confusion there? I guess you didn't have a question.
Representative Towns.
Mr. Chairman, thank you. Sponsor, collecting data is what we want to do. Collect data?
Correct.
Okay. What about if there's a person of age 15, 14, 16, 17, does that same thing apply?
I don't know the answer to that. That's something that law enforcement would have to answer.
Mr. Chairman,
Go ahead.
sponsor saying that law enforcement would have to answer something of that nature. Maybe legals can help us with that. How does this apply to non-grown people, underage people? And so I'd like for legal to give me an interpretation, please.
Mr. Chairman, would it be all right if we go out of session and honor his request?
We can do that. Out of session. Legal, please.
Michelle Fogarty, Legal Services. I can tell you that under current law, under 40-7-123, the Tennessee Peace Officer Standards and Training Commission is tasked with developing a standardized written procedure for verifying the citizenship status of individuals who are arrested, booked, or confined in any county or municipal jail. And then when a person is so arrested, the keeper of the jail must utilize that procedure to verify their citizenship status and report those individuals to the appropriate Immigration and Customs Enforcement Detention and Removal Operations Field Office if the keeper of the jail determines that they are in violation of the Immigration and Naturalization Act, or if their status cannot be determined. I don't know that a 15-year-old would be arrested and jailed, so I don't know that if they would come under that.
Well, Mr. Chairman, that's what concerns me because it's not spelled out one way or the other. And chances are they probably will be. Because as the bill, and correct me if I'm wrong, legal, the bill states that if they don't have those identifying documents, that they can be arrested. We certainly at that age of maturity, they can be arrested, right?
The bill applies to people who are already arrested for something else. If after they have been arrested for committing a criminal act, then the jailer is tasked with determining whether or not they are lawfully present.
Got it. Thank you. That's good for me.
So legal, you're saying that what this bill wants to do, we're already doing.
Michelle Fogarty, Legal Services. Under 40-7-123, when a person is arrested, booked, or confined for any period in a jail of a county or municipality, the keeper of the jail shall utilize the post procedure to verify the citizenship status of each person arrested, booked, or otherwise confined, and report those individuals to the appropriate Immigration and Customs Enforcement Detention and Removal Operations Field Office if the keeper of the jail determines that they are in violation of the Immigration and Naturalization Act, or if their status cannot be determined.
Okay, any other questions for legal while we're out of session? Representative Davis.
Thank you, Mr. Speaker. And you may be able to answer this, but last night we, on the floor, we had House Bill 2774 that was related to this. And it seems to me that both of these bills kind of go in tandem, that the 2774 was with the district attorney generals creating the report. And it seems that this legislation ensures that that information from law enforcement goes to the district attorney generals in order for them to create that report and send it back to the speakers and us. Is that your understanding as well?
I think that's correct.
That is correct.
Yes, if we pass this, this would This would say to the DAs to report to ICE and the jailers to report to ICE, or the jailers to report to the DA and the DA reports to ICE.
And to us. They create that report. The way I understand how they work together in my estimation, and I want to make sure that this is accurate, is that this current piece of legislation ensures that the jails and the law enforcement agencies gather that data accurately and give it to the district attorney generals. In 2774, the district attorney generals are the ones that create that report for us. So it ensures that they get the correct information in order to get the report to us.
That is correct.
Would you care to opine on that, legal?
Michelle Fogarty, Legal Services. The bill before this committee requires that the jailer report the information to the District Attorney General's conference. Yes.
Chairman Howe.
Thank you, Mr. Chairman. So for clarity, is that the only difference between what's in current code and the bill that we're looking at now? Is that they reported to the conference?
The current code that I just read, the jailers report it directly to ICE. This bill requires the jailers to report the information to the District Attorney General's conference.
And then they reported it to ICE.
Yes.
Representative Hardaway.
Thank you, Chairman. And to legal, does current code make it an offense to be unable to provide the documentation? Or does the new legislation that's being offered make it an offense not to provide the documentation that's cited in section 1 of this bill, amended bill?
Michelle Fogarty, Legal Services. Neither current law nor this amendment make it an offense or create any sort of criminal offense for failure to provide the documentation.
All right, so if you don't provide the documentation and the law enforcement officer or jailer, and I'm reading straight from the amendment, then a law enforcement officer or jailer may presume the individual is lawfully present in the United States based on the officer's personal knowledge of the individual. Is the offset to that if the officer or jailer does not have personal knowledge, that they will presume that the individual is unlawfully present in the United States?
Subsection B of the amendment states that a person is not lawfully present within the United States if they cannot provide any of the documents that are listed there in subdivision B1.
All right, so is there guidance in federal law on the definition of lawfully present within the United States? And
This-
how does this mesh up against that definition?
This bill defines unlawfully present as not being able to provide any of those documentations. So for purposes of this law, that definition would control. And then those persons, their information would just be provided to the District Attorney General's conference.
So is there a definition, and I know it may require some research where you can't give it to me at this time. Is there a definition or description of unlawful in the United States in the federal code? I would assume there is.
I believe there is. I'll have to look it up. I'll have to research it to give you the exact site, but I'm pretty positive that somewhere within our Code of Federal Regulations or the United States Code, there is a definition of what is deemed to be lawfully present in the United States.
Okay, so I will use the chairman as an example in the scenario I'm going to ask you to comment on. If Chairman Hulsey is caught somewhere in the backwoods, deep where the sun don't shine, without any of these documents, and nobody knows his pretty face, then he is not lawfully present within the United States. Is that correct? According to this amendment.
For purposes of this amendment, he could be considered to be to be not lawfully present within the United States. However, under subsection C, the jailer or law enforcement officer may presume that he is lawfully present based on the officer's personal knowledge of the individual. So if the officer had personal knowledge of him, the law enforcement officer could presume that he was lawfully present.
And if the officer never heard of Bud Halsey, either as a law officer nor a state representative and chairing the Judiciary Committee,
That'd be rare.
no doubt. But he could be, under this bill, considered to be unlawfully present in the United States of America. Is that correct?
For purposes of this amendment, yes, and then his information would be provided to the District Attorney General's conference for whatever purpose that would serve.
Okay, so the data would reflect the data that would be provided to the AG would say that here's one person in that data set. I don't know if we're sending names or not, but it would be recorded in the numbers, the statistics. Bud Halsey would be one person that would be reported in that data set, among others, as being unlawfully present in the United States. And you don't have to comment on this, Madam Lawyer, but the fact is that data would not be accurate. So thank you very much. Thank you, Chairman.
Representative Towns.
Mr. Chairman, I don't care where it is in the world. If it's on the moon, I still know you. This is a question for legal as well. Just say you had a group of people coming from another country that were visiting the country, touring, having a good time, spending money, you know, enjoying the sights of America, and they were stopped somewhere. And certainly they're not going to have those documents on them. But that applied to them as well, Madam Counselor.
Michelle Fogarty, Legal Services. A B2 visa, which my understanding is a tourist visa, or a valid unexpired e-passport, which is part of the visa waiver program, are two of the documents which a person could provide if requested. But under the amendment, it says the sheriff shall report the status of persons who are not lawfully present within the United States or whose status cannot be determined to the District Attorney's General Conference. So if they were unable to provide the documentation listed in the amendment, then they could fall within that reporting status.
Madam Chairman, Mr. Chairman, under the this scenario, let's say they have the documents, but they're in the room. They're on the other side of town. They're on the other side of town, and they don't have access to the documents. They may have their visa, their traveling documents, but they don't have them with them. And so at that point, they still are subjected to having to go downtown to go through that rigmarole to prove what they are, who they are, whether they're citizens or not. Would that be accurate?
Yeah.
I think that question was to you. Or was it to
Well,
me?
that was to me.
No.
Oh.
Legal.
I'm sorry, Michelle Fogarty, Legal Services. I can't speculate on the law enforcement policies or how they would handle that situation.
Thank you.
Representative Gant, you want to reply to some of that?
Yeah, I just want to, I think we're kind of losing sight of what this legislation actually does. All this is doing is collecting data. We're not pursuing somebody to arrest.
Vice Chair Gillespie?
Thank you, Mr. Chair. This is for legal still. Is there, I'm assuming that law enforcement deputy jailers, all those people, and I say this because I've witnessed it firsthand, have a way of looking up either through electronic records or through radio communications, verifying a person's identity. Is there anything in the code, in our code or US code that elaborates that? I know you mentioned the post commission had a procedure. Is that something that you could share with us or elaborate with?
Michelle Fogarty, Legal Services. Under 40-7-123, the Tennessee Post Commission is tasked with developing a standardized written procedure for verifying the citizenship status. I don't know what that procedure is. It's not in code. We just task them with doing that. And so that would be a question for someone on the Post Commission.
Representative Davis.
Thank you, Mr. Chairman. And so when I read the amendment, under section 1, the very first line under subsection A, it says when a person is arrested, booked, or confined for any period in the jail. So my understanding of this is that data is collected then if they can't verify their identity at the time of arrest or booking. And normally when you're booked, you're fingerprinted. You're run through ticks, you're run through NCIC. I mean, there's various ways that your identity is verified. Is that not accurate?
That's to you.
As far as I know, that's accurate.
It is.
You know.
Go ahead, Chairman Doggett.
Hey, thank you, Mr. Chairman. And legal may can verify this or may not have the information on that, but the fingerprinting process when someone is booked is not an immediate thing. That is sent off to the state when they do the fingerprinting. But when someone is arrested, when they're brought into the jail, there are methods in which they can look through previous booking records. They can, if they have information, a name, date of birth, a social security number, those things, if they are able to provide that type of information to, the jailer or law enforcement at that time, they can go through and check, driver's license databases and other things like that. Or if they tell them that I'm from the state of Alabama and I'm just here, there's ways that they can check that at that point. But at the same time, there's also instances, and legal may correct me on this, where an individual may be here that may not fit the criteria of this, but could potentially have a driver's license, maybe issued from another state, and not be technically lawfully present or legally present in the country, or have an expired visa or some of these other documentations.
I can't speculate on that scenario. Sorry.
Representative Carringer.
I guess this is more of a statement, but from being in other countries in the past, we were told to have your papers and your ID at all times with you, even though we were legal to be there and living there while my husband was in medical training. So, and this is just a companion piece to what we passed last night. It's a matter of reporting. And so I feel pretty comfortable with our Knox County ways that we do in our sheriff's department and our city police, that if someone is arrested and has nothing on them, that they would be able to find out pretty quickly if they lived in our area and if they were here. So with that, I guess I'm okay, and we'll be voting for your bill.
Representative Johnson. For legal. Okay, any other questions for legal? Representative Hardaway.
Thank you, Chairman. Madam Counsel, is there any assurance that every U.S. citizen, not just everyone who's here legally, but every U.S. citizen, is there a database that you're aware of that law enforcement has access to that is going to have every U.S. citizen in that database, and it's accessible to Tennessee law enforcement?
I never heard of that.
Michelle Fogarty, Legal Services. I think that would be a question that's more appropriate for law enforcement. I'm sorry,
All
I
right,
don't,
I'm
I don't
gonna
have an
ask
answer
that.
for you, sir.
All right, thank you. I'm going to ask that of Chairman Hulsey when we go back in. And the definition for unlawfully present, or the definition that fits whether I'm paraphrasing or not, is there something in our code now that defines that status?
Michelle Fogarty, Legal Services. I would have to search the code, but for purposes of this amendment, the term "not lawfully present" is defined for purposes of this amendment. So it wouldn't matter if it was defined elsewhere, because the only definition that would be relevant would be what is in the amendment.
And the definition, I'm not an attorney, but the definition in layman's terms is you don't have the documents that are listed in this amendment, nor does the jailer recognize your face.
I can read the exact language in the amendment for you if you'd like. I understand that's your summary of the language. I'm happy to read the exact language, but
No, ma'am, I think you would tell me if I was wrong, and I appreciate the gentle way that you've done so in not telling me I'm wrong, which means I assume I'm correct. So thank you very much.
Okay. Since this is the last meeting in here, I don't want to wear legal out to live to fight another day. We're back in session. There was some folks on the list. Chairman Doggett.
Thank you, Mr. Chairman, and, and thank you to the sponsor. We got some clarification about the data collection and reporting, and knowing firsthand knowledge that jailers report this information to ICE now, and this is going to be in conjunction with what is currently done through the Post Commission and what their requirements are. But one of the issues that I have still is the presumption that someone is lawfully present if they do not have any of this documentation. And you and I had spoke earlier about someone who may be homeless or indigent or something along those lines. But, there could be an opportunity, or there may be an opportunity for maybe some department somewhere just to say, well, we're going to presume that they're all here lawfully. And then that may skew the data that we're trying to collect to send. Just want to get your thoughts on that.
Thank you, Mr. Chairman. Thank you, Chairman Doggett. The way I look at this legislation is they're not being arrested because they cannot provide documentations. Unfortunately, they've already committed a crime, and that's the reason why they're being arrested. And law enforcement is trying to collect the data, whether they are here legally or illegally. And taxpayers are having to pay for the expense of housing them in jail and providing all the other required federal requirements at the same time that the state of Tennessee taxpayers are having to pay because they're here illegally. And this is a data collection only. And I know that your question is about whether this has something to do with if they're here homeless. That's not a question that I can answer from this perspective. I mean, that's going to be up to law enforcement to make that determination.
Thank you, Mr. Chairman. I know that, like we discussed earlier, the post commission does require, they have a procedure in place. Is there potential opportunity for interpretation of this to say, well, the officer vouched for this person, even though they don't have that documentation, we don't have to submit them to ICE because we have an officer who has said, yes, I know this person, I recognize this person. Is that something that may be an unintended issue with this, even though this has nothing to do with their arrest or detention? It's just a data collection, but with them being able to say, giving an officer the opportunity to vouch on someone's behalf, based off of their personal knowledge of that individual, would it maybe prevent from that information being passed on to immigration?
Mr. Chairman, the only thing I can say to that is I'm going to trust that our law enforcement is going to do the right thing when they report this data. And I think they want to get it right for the most part. There could be a lot of hypotheticals that we could throw out there, but I think at the end of the day, it's law enforcement's call to make that decision.
Leader Everett.
Move previous question.
Previous question's been called. There's objection. We're going to vote on the previous question. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. We are voting on House Bill 1128. All those in favor say aye.
Aye.
Opposed, no.
No.
Ayes have it. Moves to calendar and rules, sir.
Thank you, Chairman and committee.
That brings us to item number 2. We have a motion and second on House Bill 2035. Representative Barrett, you are recognized, sir.
Thank you, Mr. Chairman. There is an amendment. Just want to make sure it's traveling with the bill.
Let me find it. 11797.
Yes, sir.
All right. Do I have a motion and a second on this amendment? There's a motion and a second. We are putting 017797 on House Bill 2035. All those in favor say aye. Opposed, no. Ayes have it. Your amendment's on, sir.
Thank you, Chairman and committee. This bill simply takes the red flag and emergency or extreme risk protection order law in Tennessee and preempts that to the state level so that we can guarantee consistency of the law across the state from all 95 counties. So with that, I'll stand ready for questions.
Representative Johnson.
Thank you, Mr. Chairman. So once again, the state is preempting locals from doing what they can to keep their community safe. Probably the reason a local would do this is because at the state level, we are basically not interested in doing anything that keeps our community safer when it comes to putting some guardrails on guns and gun access. All red flag laws or ERPA laws do are keep the guns out of the hands of dangerous people temporarily. While they are dangerous, they will get their firearms back. This is a measure to keep communities safe. It is passed in multiple states. It is doing its job. It does not violate due process. Why will we not allow locals to do what they think they need to do in their communities? And if the state is not willing to do the job?
Thank you, Mr. Chairman. Look, Members, this bill has been in place in Oklahoma since 2020 for 4 years. Wyoming has just adopted the same measure. There are probably half a dozen other states that are getting ready to take this up as well. And the reason for that is Second Amendment rights are under attack from the federal administration. We've seen that with the resource center that's just been created by the Biden administration. So we here at the legislature are trying to eliminate the possibility of outside influences coming in and creating multiple different types of red flag laws and extreme risk protection orders across the state that's going to make it confusing not only for citizens, but also for law enforcement and judges across the state, and how and which ordinances are going to apply in different circumstances. So for purposes of making the law clear, concise, and uniform across the state, this bill is necessary.
Representative Johnson.
Thank you. So, simple question. Do you believe that folks who are a danger to themselves or others should have weapons, should have guns?
I don't have an objection to that question or that statement.
Well, I'm asking you personally, do you think that people who are a danger to themselves or others should have access to guns?
Short answer, no.
Okay, so you don't think people who have should have access to dangerous weapons if they cause a danger? Okay. Do you believe that guns should be stored securely?
I store my guns securely, yes.
So you believe that they should be stored securely?
I store my guns securely, yes.
I do too. So do you believe that we should have universal background checks?
I'm sorry.
I'll get back on the bill.
All right.
I'll stay on this one. So you are going to prevent communities to do what they believe works for their community because what the state knows better?
Representative, I'm not doing anything. The General Assembly will adopt a bill that they think is necessary to protect the rights of citizens across the state of Tennessee.
If it violates a right to a Second Amendment, then whatever county or city enacts it, then they will have the consequences for that. It's not like it's going to, it won't stand if it's not constitutional.
Go ahead.
Why does state need oversight?
The state's not providing oversight, ma'am. The state simply would be saying by adopting this bill that this is an area of the law that would have to come from and originate from the state level.
Yes, but a bill that you brought. So don't put yourself outside of this legislation because you brought the bill.
And I'm proud to do so.
Well, I can't vote for your bill because I believe it is clearly endangers Tennesseans.
Not surprised.
Okay, we have 20 minutes and we have to be out of this room. So we might have to streamline some comments or streamline some questions. Representative Fritz.
Thank you, Mr. Chairman. I'll move previous question.
Objection.
Okay, previous question been called. There's objection. We're going to vote on the previous question. All those in favor say aye.
Aye.
Opposed, no.
No.
The ayes have it. We're voting on the bill, House Bill 2035. All those in favor say aye.
Aye.
Opposed, no.
No.
The ayes have it.
No.
Sir, move to calendar and rules.
Thank you, Chairman and Committee.
As we said, item 3 is off notice. Item number 4. You got a motion and a second for House Bill 2302. Representative Representative Hardaway.
Thank you, Chairman. And I was looking to be recognized before we got on the bill. But I would just remind my members that I brag on y'all. I brag on the fact that we are a deliberative committee, and I'm proud to serve with you. And when we get on the floor, we make a big deal out of being able to thoroughly vet all of the bills that we stamp, give our stamp of approval. We say that we had thorough deliberations in committee. Please let that be the case on all of these bills.
Thank you, Representative Hardaway. I appreciate that. We're on House Bill 2302 by Chairman Howell. We got a motion and second. Chairman Howell, you recognize.
Thank you, Mr. Chairman. House Bill 2302 is known as the Ben Creedich Act. Ben was a young man with autism. He advocated for students with special needs. He has testified in front of Senate committees here numerous times. Tragically, Ben was struck and killed by an impaired driver while walking on Kingston Pike in Knoxville. The driver had recently been administered Narcan. Narcan is a prescription medication commonly administered to reverse opioid or drug overdoses. And while it does often reverse those symptoms and can save a person's life who has overdosed, the drugs can still remain in the person's system, according to the National Institute on Drug Abuse. So this bill authorizes a first responder who administers Narcan to a person to notify that person of the risk associated with driving within a 24-hour period and made aware that they could be ticketed if stopped for driving while impaired. The bill also adds driving within a 24-hour period after being administered Narcan to the DUI code. That's all it does, Mr. Chairman.
Okay, thank you, Chairman. By the way, we got an amendment I'm showing on here.
Motion on amendment code 017972.
All right, a motion. Is there a second?
Second.
There's a second on 017292. Wait a minute.
017292.
So it's this one.
Yeah,
All right.
bottom one, number 2. They both have the same code, but number 2.
Okay, you're correct, Leader. I think you did make a motion on that amendment. The
That's the
amendment is 017972 to go on to House Bill 2302. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. Now the amendment's on Representative Towns.
No, 2302. That's the amendment. Amendment 2.
Okay, any questions for the sponsor? Representative Johnson.
Thank you, Mr. Chairman. So it's my understanding that people who have been at the dentist get a very similar drug or get Narcan at the dentist. Also, it can come from anesthesia. They might be driving home from the dentist and still have that in their system. Does your bill take that into account?
Current law does. When I go to my dentist, if I'm administered some kind of drug that makes me woozy or puts me out, I'm told not to drive within 24 hours.
Well, actually, when people are like after they've even used Narcan, say they've taken fentanyl, and you use Narcan, it's not the Narcan that is not allowing you to drive. It's the fentanyl that is still in your system.
You're exactly right. Oh, Mr. Chairman, I'm sorry.
She can. Go ahead.
If I may. According to the medical profession, which I quoted, I believe it was the National Institute on Drug Abuse, even though you regain your faculties with the Narcan, the drugs that it is administered to reduce the impact of still remain in your system. That's why this bill was brought forth.
Right. And so what the concern is from the folks that I talked to is that having that Narcan in your system from the dentist or whatever, even though that does not affect your driving, the fact that it's in your system could cause a problem for them.
Chairman Doggett.
Thank you, Mr. Chairman. And I would say that in any time, even if you are lawfully prescribed medication or use medication and you get out and drive in a vehicle and you have a wreck and you kill someone, they're going to draw your blood. And if that medication, whether it was prescribed or used unlawfully, is found to be in your system, they are going to prosecute you as with vehicular homicide in that case. And so it is, I think this is a very good bill because it's putting folks on notice that, hey, friendly reminder, you don't need to be operating a motor vehicle while you have had these effects or these drugs or this remedy in your system. So thank you, Mr. Sponsor, for this bill.
I think also legal can add just a little bit if we go out of session. Legal, please.
Michelle Fogarty, Legal Services. The amendment that the committee just adopted clarifies that the presumption of intoxication is due to the underlying controlled substance and not the Narcan or the opioid-related, the opioid antagonist. So it clarifies that the presumption of intoxication is due to the underlying controlled substance that was consumed and is not based on the administration of the Narcan.
Okay, any other questions for legal? Representative Johnson.
Yeah, well, thank you for that. And that's what I was trying to say. If for some reason someone was pulled over and they did have Narcan, I'm not saying they were pulled over because they were driving erratically, but the Narcan was there. So that's what I was trying to say. And just in case I don't get called on again, I do want to point out that I do support what this bill is doing. I know very well, as being friends to the family, and I knew Ben, I know how important this bill is, but I also want to make sure we get it right.
Any other questions for legal? Representative Hardaway.
Thank you, sir. Madam Counsel, are there any legal implications, civil or criminal, for the failure of a first responder or the dentist to inform someone of the potential impairment that they may have from drugs?
Michelle Fogarty, Legal Services. This amendment states that a first responder who administers an opioid antagonist may provide information on the risk associated in an effort to ensure that the individual is informed of the potential dangers and legal responsibilities. There is no liability imposed on the first responder under this amendment.
All right, thank you, ma'am. Thank you, Chairman.
All right, we're back in session. Leader Lambert.
Move previous question.
Previous question been called. We are voting on House Bill 2302 to go to calendar rules. All those in favor say aye. Aye. Opposed, no. Ayes have it. Moves to calendar rules, Chairman. That brings us to item number 5 on the calendar, which is House Bill 2082. You have a motion and a second. Representative Fritz, you're recognized.
Thank you, Mr. Chairman. If you don't mind, I'll sit here today. There are several amendments. I would ask that we keep it under the 18335 amendment for the discussion today, if that's agreeable to yourself and committee.
Motion 018335.
Second.
There's a motion and a second on 018335 attaching to House Bill 2082. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. The amendment's on, sir.
Thank you, Mr. Chairman. I would just offer that this bill would move to correct Tennessee Code from 1989, where currently under Tennessee law, a person commits an offense who carries with the intent to go armed. This current code assumes a crime rather than relying upon the presumed innocence of the person. It is, I would offer, in direct conflict with the Second Amendment to the United States Constitution and Article 1, Section 26 of the Tennessee Constitution. I would offer further that our Constitution assumes the rights of natural law and nature's God when it concerns matters of self-preservation and self-defense. And the authority of the people over the government is contained in our Constitution. That the government actually has boundaries to which it can and may not operate within. This bill seeks to ensure that. Shall not be infringed is a clear statement. And citizens of the state have a right to keep and bear arms. These rights are assumed, I would offer, in perpetuity in our Constitution. The Constitution sets the boundaries and the processes of the government, and all law must be consistent with the Constitution. Would offer just a few brief comments, Mr. Chairman, and I'll close quickly. What this bill does in its current posture, it removes subparts A, E, and G of 3917-1307. And by removing A, Tennessee law would allow citizens to join 46 other states in the United States, including every state that touches Tennessee, with the ability to lawfully carry rifles and shotguns. By removing A, was suggested, and there's a friendly amendment that you see on the bill, to remove 1308. That is within the language that you see. It cleans up some associated language with statuses as recommended by legal staff when we did these amendments. And it further separates the state of Tennessee from states like New Jersey, New York, and the District of Columbia, where individual rights are not honored. It brings Tennessee in compliance with the holding of the United States Supreme Court in the Bruin decision. What it does not do, it does not change any laws prohibiting felons from possessing firearms. Does not change any laws regarding prohibitions on people with domestic violence convictions from possessing firearms. It does not change any laws regarding prohibitions on people with stalking convictions. Does not change any laws prohibiting people with mental health adjudications from possessing firearms. And again, it does not change any laws which regulate when a juvenile can legally possess a firearm. And finally, it does not change any laws regarding the age limit for the purchase of firearms, much of which is controlled in 18 U.S. Code 921 and 922. I would offer these comments as a closing remark, Chairman and Committee, and I appreciate your forbearance. Our Constitution applies 24/7, 365. And we have no authority to abridge the rights of the citizenry. And I would offer further in this time, as we discuss often, and you hear me often talk about the crisis with illegal aliens we have in this country, to not fully honor the rights of Tennesseans is the wrong thing to do. So I have, Mr. Chairman and Committee, I've been unsuccessful in being able to accurately communicate the information. And as you know, the bill is held up in the Senate. I take responsibility for that. And what I would ask, Mr. Chair, is that we hold the bill in its current state. And if by some act of divine providence, the Senate does move on that bill, I would ask that we reopen and reconsider that bill. And with that, I would yield to the will of the committee, Mr. Chairman.
All right, thank you, Representative Fritz. You are correct. It is parked in the Senate, and unless they open a committee to hear it, it won't be heard. So unless there's objection to it, we will hold this bill in our committee to see what the Senate does, and if we will go from there. Any objection? Leader Lambert.
No objection, but I do anticipate we're about to adjourn in a moment, Mr. Chairman, and I just want to be the first of probably a couple to say you've done a mighty fine job of guiding us this year in this committee, the last 2 years, and we have enjoyed your wit. We have enjoyed your stories. We have enjoyed the interesting procedural maneuvers that you have sometimes created that have moved us along well, and we appreciate that. So, Mr. Chairman, thank you for your leadership on this committee.
You're very kind. Thank you. The intern of all interns has a gift for you. If she will commence to send those down, I want you to know, folks, I appreciate you more than you know, and I've said before, yes, sir.
Motion on that, we need to take it off notice, and then he can put it back on notice if he wants to do it again.
1882.
Or 2082.
Okay, I'm told that I need to gavel to hold this on in the committee. So all those in favor of holding this bill in the committee, that is 2082, say aye. Opposed, no. All right. Ed, yes, sir.
I would like to echo what the leader said. It's an honor and privilege for me to serve on this committee. And there's something about wit and wisdom, which you have an abundance of, that goes a long way in guiding this committee through the deep waters of the legal process. And it is an extreme joy for me to serve with you on this committee. You do a great job. Thank you, Mr. Chairman.
I appreciate that very much. Thank you. I brag to people on the other side that this is the best committee there is with the best folks on it. And you have done very well. We've gone through some deep water this year. We produced and not produced, but furthered and corrected a lot of pretty heavy lifting bills that I think are good legislature. And you've done a great job. And I appreciate you all more than you know. So without any objection.
Objection, sir. I've had my
I'm
hand
sorry.
up for
I'm
about an
sorry.
hour here. And for the right reason. I want to echo the many accolades that you've received about your wit, your charm, your wisdom, and definitely your good looks. You know, I can't wait to get to committee to receive my dose of daily or weekly Bud Halsey. So I like my fellow colleagues, and there is no both sides of an aisle up in here. Well, most of the time it's not. But I want to thank you for the way that you run your meetings. I want to thank you for being an example, a model for other chairmen in our Tennessee General Assembly. So thank you, Bud Halsey.
You're very kind, Representative Hardaway. Thank you very much. All right, everybody get your homework. All right. Without objection, I needed a motion to adjourn. We are adjourned. Thank you.
Subject to the call of the chair. Subject to the call.
Subject to the call of the chair.
All right. Good work.
You know, I don't.